उल्लंघन में नहीं हुए। और अंतिम पक्ष जो रखा हमारी तरफ से, दलीलों का मैं समक्ष आपके सामने रख रहा हूँ। जो आखिरी रखा वो ये था कि टेस्ट क्या होना चाहिए। इस चीज़ को निर्णय करने के लिए कानूनी टेस्ट क्या होना चाहिए। कानूनी टेस्ट कभी भी सिर्फ विधायिका में इनके नंबर ज़्यादा हैं मेरे नंबर कम है ये नहीं चलता है। हमने दिखाया कि विधायिका में भी हमारे नंबर ज़्यादा हैं। अगर आप सभी विधायिका लें, महाराष्ट्र की असेंबली, लोकसभा, राज्यसभा इत्यादि इत्यादि। लेकिन दूसरा, सिर्फ विधायिका का टेस्ट ही नहीं है कानून में। उच्चतम न्यायालय ने ये कहा है बार बार कि विधायिका का टेस्ट नहीं है। टेस्ट उतना ही आवश्यक है जो संगठन का टेस्ट होता है, जो संगठन की संख्या का टेस्ट होता है। तो ये 4-5 मुद्दों में हमने रखी है दलील। 4 तारीख को कामत जी समाप्त करेंगे और मैं अपनी बाकी जो बची हुई दलील है उसको रखूँगा। उसके बाद चुनाव आयोग दूसरी तरफ को सुनेगा। फ्रेंड्स, just to summarize our contentions, first and foremost we pointed out to the Election Commission, the hearing of which just finished a short while ago, that the other side, the so-called Ajit Pawar group, is spreading canards and doing things which are completely impermissible, unacceptable, saying that the hearing will end in so many days, the judgment will come in so many days. They are being completely presumptuous, completely taking the Election Commission for granted, and we complained about this to the Election Commission. The Commission has warned everybody not to indulge in such activities. Specifically, they told us not to do that, and of course this was done only by the other side. We have never done it, we don't believe in it, and we condemn the other side's activities in this regard. Secondly, the Commission has said that the argument before them that everybody from the other side has willingly participated for decades, for over 20-22 years, without protest, without demur, without objection. And today the same persons are objecting, and the case law on this was cited, namely on estoppel and prevention of the same point being taken to which you have agreed. Thirdly, from our side, the principal contention was how the elections to a party cannot be challenged in these symbol Article 15 proceedings. The symbol proceedings have no jurisdiction, we said. This is our contention I am summarizing. That in that you challenge the elections to a particular party. That is a different jurisdiction, and my colleague cited Supreme Court judgments to show that such a challenge cannot be entertained in a section or an Article 15 proceeding. The other point which was argued was to show how each and every provision of the NCP Constitution has in fact been completely obeyed and implemented in letter and spirit in each election, even though such elections cannot be challenged in symbol proceedings. How these arguments are factually and legally wrong, and that was elaborated as a contention. And lastly, it was pointed out from our side that the people on the other side are completely grievously wrong in assuming that the test for deciding this, the legal test, is only a legislative numbers test. Firstly, we said and we argued that even legislature wise we have the larger numbers. If you look at the holistic picture of legislatures, which includes the Maharashtra Assembly, of course, the Lok Sabha, the Rajya Sabha, and therefore that is a holistic test. The legislators in other states, not the deliberately self-serving, self-invented narrower test by the other side. Secondly, we cited case law to point out that organizational numbers is being the preferred and the major test by case law of the Supreme Court. The other side is deliberately trying to altogether ignore organizational numbers as if they don't matter, as if they are of no relevance. And I think that is again a wrong legal test, which is what in our contention we tried to demolish. The hearing will continue on Monday the 4th, and after my colleague finishes, I will deal with the other remaining arguments, and our arguments should end around then. Thank you.
लोकशाही मराठी ऐका, पहा, जागरूक रहा.